Hi, I'm Greg Dell with Dell Disability Lawyers, joined by attorney Cesar Gavidia, and we're going to discuss one of Cesar's recently resolved cases against the Standard. And I know this was a tough case for you. It was for a state employee, but I'd like you to give us the background of the case, and then we'll talk about some tips about what the claimant might have been able to do to avoid denial, and then some tips that people could take away to help win their appeals in the future. So let us know what was going on in this case.
So our client, like you said, worked for the state of Oregon. She was, they titled her as a senior procurement specialist. It was also identified as a technical customer support representative. And she'd worked there a long time. She had a lot of benefits working for the state. One of those was her long-term disability policy through Standard Insurance Company, which interestingly was also a company that is incorporated and is basically headquartered out of Oregon, yeah, out of Portland. So it was their very own backyard here. They had the entire contract to insure basically statewide all these representatives for the state of Oregon. Well, she'd had a history of back issues, orthopedic issues. She'd undergone 2 knee surgeries, 2 hip surgeries, 3 back surgeries, fusions. She'd undergone stimulator implants.
You just listed 7 surgeries.
7 surgeries, 7 different surgeries.
And she got denied benefits.
She got denied benefits because, you know, she really, to her credit, every time that she would have a surgery, she would go back to work and work through all of the complications, all the limitations. And the insurance companies don't see that necessarily as a virtue, as something that, well, we should credit this person. Look how reliable their claim is, or how credible this is, because they've always managed to work through all this pain. No, what they'll say is, you've managed to work through all this pain. You've had all these problems in the past. You've managed to work your sedentary jobs, because they'll classify it in this, you know, kind of broad physical demand category. And why can't you do it now? She developed over this long period of complications and surgeries, lower back radiculopathy, failed back syndrome, a host of different orthopedic neurological symptoms that really created a lot of challenges for her to sit down and do a 40-hour plus a week job at a desk working full time. So,
oh wait, back up. They did pay her, right?
They did pay her. I mean, she filed her disability claim. They actually paid her for about 1.5 years. And we talk about these own occupation periods and any occupation periods. And under this policy, the first 2 years she's covered for her own occupation. At about 1.5 years, they do a physician review. They usually do this to determine whether they're going to be disabled from any occupation, right? So this doctor, who was a board-certified neurologist that Standard found somewhere, probably through some third-party vendor they reached out to, essentially looked over the medical records.
But this wasn't one of their own goons?
No, it wasn't one of their own doctors. This was someone that they had contracted out with, and they just simply wanted him to do a records review. No examination of the patient or the claimant, just a straight records review. He reviews the records, which are voluminous, and says and concludes basically, well, I don't see any evidence to support that she has radiculopathy. Mind you, she has failed back syndrome and all these other things that he concedes, but on that one point that she doesn't have radiculopathy because the imaging or the MRIs don't support that she has radiculopathy, that she doesn't have nerve compression.
Question for you, why does that matter? Did the policy say you have to have radiculopathy?
No, it doesn't matter at all. The only reason that he essentially does this is to discredit her claim, discredit her complaints, discredit her completely. Because what he did is, although he says, okay, no evidence of this serious neurological symptomology she claims she has because the imaging doesn't support that. I'll agree to all these other things that he basically couldn't disagree with, but I don't find that she's not able to work a sedentary job because of these things.
So just so people understand here, and we're not doctors, but we've become extremely knowledgeable in the area of what it actually takes to prove a type of disability. And we know that when a doctor says the MRI doesn't show evidence of radiculopathy, that is complete garbage. It's not a truthful statement, because someone could have no herniation whatsoever, no neuroforaminal narrowing, no osteophytic formations, basically nothing that looks in the MRI, and that doesn't mean they don't have radiculopathy.
Right.
That just means it's coming from somewhere else. So we know when the doctor says that he's basically, like, in my opinion, just hiding in his, in his comfortable home, writing these reports saying, I looked at your MRI, even though you already had 2 back surgeries, and I see no evidence of radiculopathy. But the radiculopathy comes from a damaged nerve, root, or a damaged spinal cord. So the damage is done for your particular client. It's over. The radiculopathy is still there. What happened when she had surgery was that it kind of stopped the pain or the impingement or whatever was going on. So
Right.
It's borderline fraud for him to say, now I'm looking at the papers and I don't see evidence of radiculopathy, because you know what? No such thing may exist, and it doesn't have to exist.
Right.
So sorry to interrupt you, but it's just frustrating because we see it every day, and it takes people like us who know what we're doing every day to say to the insurance company, what your doctor did, there's no other way to put it, it's bullshit. It's complete nonsense. So anyhow, sorry to bother you.
It's okay. So, no, but I'm glad that you touched on those points, because this doctor then basically looks at these other conditions, these other supported, in his opinion, supported diagnoses, and says, although she has, failed back syndrome and, lumbar disc issues and hip issues and knee issues, I still think she could do a sedentary job. The restrictions and limitations that I'm going to provide an opinion to is going to satisfy that she could work a sedentary occupation. And with that opinion, essentially Standard says we don't find that you're eligible any longer from disability from your own occupation.
So we understand their basis for denying. What did you do in order to overcome this wrongful
denial? So it was obviously critical that we had to really do a profound analysis of the medical records. We didn't need to, in this particular case, reach out and conduct a functional capacity exam because her doctors were extremely supportive. We reached out to her doctors. They provided very specific opinions in terms of what her restrictions and limitations were. And I think basically what also happened with the appeal was that the Standard in their own review probably saw the flaws in this peer review's report and in his review of the records. So once we were able to do this thorough analysis of the medical records, they actually had also done a vocational assessment, which was not necessarily flawed or in any way. It's just that they were agreeing that given the restrictions and limitations provided by this peer review doctor, she could go back and work a sedentary job. We were just saying she couldn't work a sedentary job. We're not saying her job isn't a sedentary one. Her own occupation isn't sedentary. It's just that she couldn't perform that occupation. So it was really just attacking the medical opinion of this doctor, highlighting the supportive records and opinions of her doctors. And she also had some really important critical records from pain management and physical therapy that I didn't see Standard had really done a review of and considered in their reports, in the peer review report or in the analysis and review of the denial. So we've submitted all of that, and within a period of time, probably I'd say within a couple of weeks to a month or two, they overturned the decision and they approved it.
So I think what was so great in what you did that puts and explains the reason why people need someone like you and us to write these appeals is that her medical condition didn't change from when she was denied until when you got involved with the claim. It wasn't like something bad happened and we said, oh look, she's so much worse. But what happened is that it had to be presented to them in such a way where the Standard cannot find any person who could disagree with the manner in which you as an attorney have presented the evidence. And they get stuck in a spot where if they do disagree with it, it has no rational basis whatsoever. And even if they do disagree, then we know we're gonna win in a lawsuit, which is the next step if you didn't win the appeal. But it's an art to doing that in the manner in which you do that and put together all the medical records. And knowing that I know you've done thousands of these and you're like, well, we gathered this record or we gathered that record and then we put stuff together, I understand that it was it's a lot more than that because it goes along with the brief that you end up submitting, the additional support when you reached out to all of her doctors and you got everything. So it's a fairly complex analysis, and it's all how you put it together, because the standard calls clients like yours and says, hey, you got denied, just go ahead and send us some information on why you disagree, and then we'll make a decision. But that's not the way it's really done.
Right.
Because if you do that, you're going to get denied for sure. So congratulations on this claim. It was great that you won. And now I know you did that during the own occupation period, but what's happening with the change in definition?
So with this particular client, she's actually, and she's very determined. I mean, I think to her credit, you see a lot of people that they may not necessarily try to function to what their limitations are, and she does. She's actually working part-time for a company that allows her to work from home. Okay. She only is able to work a certain limited number of hours, obviously limited by her medical issues, and she earns a certain amount, but given that it's in the any occupation stage, as long as her income stays below 60% of what she used to earn, she still qualifies for her benefits.
Well,
or percentage of her benefits.
I remember when this case came in and when we were working on it, it disturbed me greatly because it's not often we have someone with 7 surgeries who then gets denied benefits. Like, right. Under the knife 7 times, risking your life, and then to basically say, well, I see everything here, we don't deny it, but it's not severe enough to disable you. And I mean, that's why, I'm passionate about what we do, because we get to help help people like this, but it's ridiculous that another human being working for Standard and a doctor looked at this and says, no, I think you can work 40 hours a week, 5 days, 5 days a week, 8 hours a day with reasonable continuity, with no issues whatsoever, and you shouldn't have any pain or discomfort that's going to affect your ability to do this job. It's a ridiculous basis. But luckily, there are humans at Standard and these other companies who do take a second look at it, and thankfully we have this appeal process, and they do look at it and go, you know what? Someone got it wrong, and we should approve the benefits. So that's great that you were able to have that outcome. So if you're someone who has a Standard long-term disability policy, feel free to reach out to Cesar, myself, any of our disability lawyers. No matter where you live in the country, we always provide you with an initial free consultation, and we look forward to the opportunity to speak with you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.